Debate on the legality or otherwise of the Kadhi courts in the Constitution has been further fueled by a Constitutional Court decision today. Judges Joseph Nyamu, Roseline, Wendo and Mathew Emukule ruled that the Kadhi courts were discriminatory and inconsistent with the Constitution and therefore illegal. They ruled in a case that was filed in 2005 by 26 applicants led by the then PCA moderator Joseph Nyamu, Bishop Silas Yego of the African Inland Church, current PCA moderator David Kadhi, and Bishops Margaret Wanjiru, Arthur Kitonga, and Boniface Adoyo. The judges ruled that the existence of the Kadhi courts in the Constitution were against the principle of separation of state and religion. The Constitutional Court also directed that the jurisdiction of the Kadhi courts was only limited to the 10-mile coastal strip, as agreed between the then Sultan of Zanzibar and the Kenyan mainland. But top constitutional lawyers have faulted the judgment.
Looked at from the point of view of constitutional theory and practice, this decision is wrong. Of course, what appears to be the case is that the court interpreted the whole of Section 66 narrowly.
Obviously, people are entitled to raise questions as to why a case that was filed in 04, I think it was, the arguments and hearings submissions were concluded over 2 years ago, and now on the eve of the referendum, that is when the judgment is being handed out.
The judges also ruled that the Kadhi courts should not be maintained using the taxpayers' money, saying doing so was sectarian, discriminatory and unjust.
Every Muslim in this country pays money. They are taxpayers. So they pay money, and therefore their money go towards paying the salaries of the magistrates and judges who hear cases of divorce and succession in respect of Christians. Where is the fairness for the Christians themselves to say, we do not want our taxpayers' money to pay the Kadhi court?
However, the three judges did not rule on the existence of the Kadhi courts in the proposed new constitution. According to the Constitution of Kenya Review Act of 2008, only the interim independent constitutional dispute resolution court can arbitrate on the issue.
This judgment must be seen in context. It has absolutely nothing to do with the current process.
Constitutional lawyers also raised questions on the timing of the ruling by the three judges, just 2 months before Kenyans determine the fate of the proposed new law, in which the Kadhi courts are entrenched but as subordinate courts, dealing only with matters relating to divorce, inheritance, marriage and personal status.